What did you know about the Jehovah's Witnesses?
Look, a very good question. This had never been asked in such a precise way. Well, look, it's clear that for 10 years I've had my PhD degree and I worked on crimes involving sectarian groups or alleged sectarian groups. And within these alleged groups, there are some very striking criminal doctrines and legal theories that concerns Jehovah's Witnesses. Traditionally, in criminal doctrines, there has been a lot of debate about what is called conscientious authorship. When I did my doctoral PhD degree in the past, we were asked to create an advanced studies diploma, a kind of master's degree, and I had to do a year's research on what conscientious authorship is. So what this means for those people who commit crimes because morally they consider it necessarily and within the exemption of military service to those in a position to not take up arms. And in this case, they do not go to military service, and also conscientious crimes as electoral exemptions / crimes in Spain. These sectorial groups, although they are very minor crimes, for example, not showing up at the polling stations, members have been sentenced for the omission of duties and in other cases omission of assistance to consent to blood transfusions for minors or children unable to decide and if they are not mature enough. These have been well debated, but honestly, I knew very little, and I have to admit I did not know all the problems or reasons within these internal issues within the Jehovah's Witnesses and the internal dynamics regarding the authorship conscientious that goes in hand with these victim cases.
Why doesn't justice act against religious crimes?
Well, here you have to be very precise because first of all, the sentences are criminalized to just members of the Jehovah's Witnesses. For example, it is only individuals like Catholics are condemned, not to the Catholic confession. It is another thing to link these crimes to a religious confession. It is like saying to transfer the responsibility of the authorship or in some way certain criminal responsibility of the legal person to the legal entity that is obviously more complicated. That is to say, the sentences that exist in Spain on crimes committed by conscious authorship, that is to say, traditionally they have always been to the members. Today there is no sentence that links the conduct of any organization per se. That is to say, parents who have omitted the duty of relief to minors or children because they are not mature enough, etc., or electoral crimes that have never been linked to religious organization in this case, in which we are talking about Jehovah's Witnesses. It's like saying, for example, the Catholic Church, therefore, Catholics also commit sexual abuses within the church, but to this day, it has never been linked or it has never been proven that the Catholic Church is responsible for a cover-up, at least up to this day. So it is the same for the Jehovah's Witnesses organization, the Watchtower.
What is the difference between a sect and a destructive sect?
In general, or normally in the social area, everyone can think what they want about what a sect means, of course. One takes the dictionary of the Royal Academy of the Spanish language and there are 3 sections in the sociological part, and in the last section in which it speaks of absolute control of the leader or leaders, and absolute control of the members is not a criminal or legal word, so therefore everyone can think what a sect is. In the social heritage, it can be something positive or negative, like the Catholic Church was split off, or rather from Judaism. Therefore the word sect, each one considers socially what they want in a positive or negatively way. But I debate this point in my PhD thesis, and obviously I cannot eliminate the social heritage. I cannot eliminate sect. There are other names for this type of groups, such as a group of psychological manipulation or a group of manipulation or psychological abuse, but it seems correct to me as it's a very understandable word to use the word sect. Everyone knows more or less what a sect is, which in the end is something like a religious movement, but it is something that alarms us or causes us a certain commotion due to its strangeness, due to the structure, or due to a certain secrecy to society. Therefore, based on that idea of a certain, let's say, logically fear of how an alleged sect was organized socially, I understand that the most correct thing to call this group would be criminals, to say that they are criminal sects when they commit any crime, but more specifically when they use cognitive persuasion that has traditionally been called brainwash, coercive sects, which is a terminology that is certainly succeeding because it also equates with the current terminology in the use that is a persuasion perspective, that is a way of calling a certain group or a subtle indirect classification.
What are the latest news of the judicial hearing after 5 court sittings?
Oh, well, there hasn't been a 6th sitting just because God didn't want it to happen. Just to use this expression though. Well, I'm going to be very clear. I'm going to be very, very clear here because I haven't said this anywhere else and I don't even think I've said it before. In the first sessions were very tense. They're very, very tense, specifically because the first witnesses were Jehovah Witnesses and then ours. But already with the first ones were fundamentally good. In my work as a lawyer for the association, I started seeing the first contradictions from many of the answers given by the Jehovah Witnesses, and that's a lot of work. The strategy that we follow was very hard. The plaintiffs did not expect it, and that created a certain amount of tension, a lot of tension actually, and led to even more tension on the other hand. They did not expect my questions to be like they were bringing out all the contradictions to light, which I understood at the time there were certain contradictions from their own witnesses, and that led to a greater tension and ultimately led to the trial. And let's say that in my opinion they were deflating. I believe they came with high hopes. They were very clear about it. We bring here 12 Jehovah Witnesses to testify who are going to tell the whole truth. In the first 2 sections, they saw certain contradictions between them and between one and another and with oneself. The following sessions were more calmly between the parties, but very hard because we listened to the detailed account in all of the victims. Things very serious, very, very serious for me. And it has been a very tense trial for myself. Psychologically, not only because of the job that I had, but also because that confrontation and listening to all the experiences from the victims. My first initial job, which was to look for those contradictions, meant a very important psychological and professional effort for me, and listening to the victims live and direct also made a great impression on me without any prejudice. I believe that the cases were very tense and it was and the Jehovah Witnesses were deflating because even the other party was seeing the truth, not only the veracity, but the truth of what the victims were saying.
What can you tell us about the last day in court?
From the last session, I am left with a very technical question. Perhaps the first thing to say is that all the victims testify very well, because when someone tells the truth, no one can testify wrong, and it is impossible if you know the truth, because it has happened to you. You have not only your feelings as a victim, but you know precisely with your memories everything that has happened to you. Therefore, the last trial happened with the 4 victims' testimonies who declare, and they were very precise, very clear about everything, the organization procedures, the doctrines of everything that what is going on inside of this organization. Whenever you want, we can talk about it, although I think that everyone who has been a Jehovah's Witness knows very well this, and especially the ones that has been disfellowship. But I will be left with these three things to say. The first one is that the lawyer for the party of the Jehovah's Witnesses, the plaintiff of the religious organization of Jehovah's Witnesses, well, first, they asked very few questions to the victims. I don't think that's because they didn't want to ask anything, but because they realized that if they ask anything further, it will prove or reaffirm the victims' veracity of their claims. Therefore, they said, we are not going to ask any further questions. Number two, they attacked the issue of being a victim and the disorder that comes with being a victim, or how they felt. I personally see that tactic as grotesque, rude, and insulting to me personally. Why? Because first of all, it is not a judicial procedure. Therefore, to attack a victim this way when the opposite party, the plaintiff, knows perfectly that the objective imputation of the offender criminal trial, they are not psychological experts. If I remember correctly, the judge had to intervene at some point to stop any of the questions because they were putting precisely even the psychological disorders, a term that is not a criminal trial, and this caught my attention that it is a desperate maneuver in my opinion. I would never have done it because here I respect the victims. I have my own way of proceeding. It doesn't seem to me that it was an elegant way of the Jehovah's Witnesses lawyers. The final report is to summarize what happens in the trial, in the practice of the evidence, not to tell you again the sentences and what the lawsuit is. The final report is to summarize what has happened in the court, in the trial, in the practice of evidence, not to tell the whole story again of what the lawsuit is. The final report is the count and the demand of what has happened during the court, and not to tell the judge of what the European Court of Human Rights thinks about Jehovah's Witnesses, or what Belgium, or what Norway, or Beijing. It doesn't matter because this is an independent trial from them, from Spain. And I believe this was a desperate tactic from the Jehovah's Witnesses lawyer. What are they going to say in the trial? They didn't have anything to say because they knew that all the witnesses, all the testimonies that the Jehovah's Witnesses said, it was contradicting themselves. So they were reaffirming the ostracism, the shunning doctrines, and in the sense that they did not want to speak they didn't want to speak to any of the other parties because they were disfellowships. They think it is someone, oh well, these people are very close to Satan and he was going to say these sort of things anyway. So they refused to talk to the other party. So therefore they were reaffirming that the victims were being shunned. So therefore they didn't say anything else.